topics and ask your questions to seek advice regarding any legal matters pertaining to British law. So for everyone in the UK today, this show is for you. If you're going through any legal matters and you'd like advice for them, we have our specialist solicitor with us today here to answer your questions. So this is Legal Hour. We're now live, and the number to call us on is 0203 637 6857. That's 0203 637 6857. That'll bring you right into the studio to speak to us and ask your questions. Also, you're able to send your questions to our WhatsApp number on 074 2239 8833. That's on 074 2239 8833. So without further ado, we'll get started with our show now. My name's Ibrahim. I'll be your host for today, and joining us is our special guest today, Brother Suhail Sibtain. Assalamu alaikum, Brother Suhail.
How are you?
I'm well. How have you been since the last time we've seen you here?
Very good, very good. Yes, just working hard as usual, and now happy to be back.
Alhamdulillah.
And also enjoying the rain as I came in.
Yeah, it's been raining.
Yeah.
We're both quite soaked, but alhamdulillah,
yeah.
It's good. You know, I was thinking about it coming here that you're one of our regular guests now on the show. You know,
Yes,
before I'd have to ask the guests to introduce themselves, but now you're quite regular with us. I'm sure our viewers know you very well. So
Sure.
just for our viewers at home, the topics for today that we're going to be covering is dispute resolution and enforcing a court judgment in regards to debt or debt recovery. Correct?
Yes,
Brother,
exactly right. Yes.
Brother Suhail, thank you so much. So if you have any questions and you're currently you owe the debt or you owe a debt, you'd like to know how the steps are to go about maybe paying it back if you can't afford to do so. If you'd like to know the legality pertaining to everything, if you'd like to know what your rights are in both own a debt or having to pay one, then do call us up. Also, we'll be covering dispute resolution. So be sure to reach out to us. Also, you're able to join the discussion. If you've been through anything pertaining to these two topics and you'd like to share your story, then you're able to call up and have a discussion with us. We're probably able to hear your story, and that will benefit everyone or anyone else going through the same situation at home as well, inshallah. So, Brother Suhail, to start off the show, I'd like to ask you to give us an overview in regards to both of these topics. First of all, dispute resolution. What sort of things things come under dispute resolution? What is dispute resolution, and when should it go to a legal, to that legal stage?
Yes, yeah.
And also in regards to enforcing a court judgment in regards to debt, what does that mean? What comes under this, and who is it relevant to in particular?
Okay. So dispute resolution is a large field in itself, and it will cover any type of litigation and any course that a party may take prior to litigation. So if there is a dispute between a claimant and a defendant, whoever that may be, and they wish to either pursue it as far as litigation, then they would first of all consider dispute resolution as a way of resolving their dispute. There are many ways of doing that. For example, you may settle out of court, you may reach mediation or arbitration. Litigation is a last course of action that one should consider, where you have exhausted every other course of action and you feel that now court is the only alternative for you and your other party. So we come to a judgment and a judgment regarding debt. For example, if a defendant was to owe you a debt and you pursue the claim at court, and either due to the party not responding to your claim or not responding sufficiently or adequately, you can then get judgment in default against them ordered by the court. The consequences of having a judgment in default awarded against you are very, very dire indeed, including the fact that your credit file will be affected for up to 6 years. Even if you come to an arrangement with the claimant in settling that debt, the mark or the initial indication of being in debt will still remain on your credit file for potentially up to 6 years, and therefore it's of vital importance to either have that judgment withdrawn by paying it within 28 days, or coming to some sort of arrangement by way of a consent order, having the debt paid in full, and then applying to court to have that judgment removed from your credit file, and that can then be amended by the credit file agency. But essentially that's dispute resolution in a nutshell.
All right, then, thank you so much. So we'll get started with our first question of the show. So first of all, how do you obtain a court judgment for an unpaid debt?
Okay, so if you have a debt owed to you and you want to pursue the matter in court, the process is very easy. So you would initially obviously issue a letter before claim, giving the other party 21 days to respond. according to CPR protocol, according to the protocol that the court governs and gives to us. If the party does not respond and you feel that legal action is the only course of action left, then you would issue a claim at court. The court again would give a certain amount of time for the defendant to respond. If the party either responds but the matter continues to court or doesn't respond at all, you can ask the court to enter a judgment in default. And that simply means that the court will issue a court order saying that the party must pay the amount forthwith.
Okay.
And as the point that that happens, that will show on your credit file. So that's essentially how you get a judgment in default against a person. Another way would be to, for example, wouldn't be a judgment in default, but if the matter goes to court and you win a case, you can again be awarded a judgment against the defendant.
Okay, so a judgment in default is where the individual doesn't show up or you can't find them, correct?
A judgment in default is where the party hasn't responded, so they haven't filed a defence in court within 21 days, or if
after receiving the letters.
After receiving the claim form from the court, or if they have responded, either they haven't complied with CPR protocol and therefore their defence has been struck out, or they just haven't responded at all, and therefore that's called a judgment in default. And
judgment in default means that now it's official that they have to pay this debt back.
Yes,
because they haven't taken the opportunities to defend themselves or to explain the situation or anything.
Exactly right. Yes, yes. So now it's made official. The court has issued a court order saying that you now have a judgment against you in default. You must pay the amount forthwith, and the only way you can get the judgment removed is by consent of the claimant, or by paying it within 28 days and having a judgment withdrawn.
Okay. All right then. Thank you so much. And in the situation that the individual can't be found, what do we do now? If a company is chasing debts up in regards to someone, they've gone to court, but they've sent these letters. However, possibly no one's opening these letters. The individual's possibly moved, and a default in judgment, correct?
Yes.
Has been made. And the individual comes and says, I haven't received these letters. That goes into a different matter, are they telling the truth or not, but let's not go into that. But they're saying, I haven't received the letters, I've moved, or it's gone to my old address, or I don't know what's going on, you know, once they finally hear news of it.
Yes, of course. So many a time you would find that the defendant can't be found, it can't be traced. In that situation, you need to weigh up the pros and cons. So would it be better, for example, if you actually take the matter to court in the first place, if you know the party is going to go missing, you wouldn't be able to enforce that judgment against the party later on. And therefore, you need to ask yourself, is it worthwhile taking the matter to court? Is it worthwhile getting a judgment? If, for example, you get the judgment in default against the defendant and then the defendant goes missing, then it may be advisable for you to maybe instruct an investigator or to instruct someone who has specialty in that field to trace that person. Get a trace report, find out where that person is living or fixed residence, and you can then follow the steps in getting that judgment enforced by way of instructing a bailiff or any other means. But that would be what you'd have to do if the person can't be traced.
Okay then, thank you so much. We have a question from our viewers. Our first question is, if you need to pay a company back some money which you're aware of, and then after that you start receiving contact from a different company which you haven't heard the name of, but it's chasing up this specific debt which you owe the other company, and you research the name and you find that it's a debt collection company. How do you go about dealing with this now?
Okay.
Considering that they're placing additional charges in addition to this, and they're probably a bit harsher about it. Yeah,
of course. So what companies now tend to do is they would hire, instead of using up their own resources and their own costs and whatnot, they would hire a company to chase a debt collection agency. The debt collection agency, their job is purely and primarily to get the debt back, and on top of that, they would be adding the charges for every visit they make. So my answer to the caller would be to contact the agency straight away and get an arrangement put in place. If you feel that you're not going to contest the debt and you have admitted to it, then you need to make sure you contact them and get an arrangement in place to stop and prevent any further charges from being accrued. If you don't do that, what many people do is that they still try to contact the actual claimant and say that, look, I want to pay the debt back, instead of contacting the actual debt collection agency. The risk that runs is that they will keep on attending your premises, they will keep on contacting you, and every time they do, they're adding the charges on. And therefore, the best course of action would be to contact both, make sure you have everything in written form, and you have evidence of that, and make sure you get an arrangement put in place as quick as possible to prevent any further charges, providing you're not contesting it. If you contest it, you need to make sure you contest it fully, as quick as possible.
All right then, thank you so much. So our next question for today's show is, what are the consequences of a judgment being taken against you, or a judgment against you?
Okay. The consequences, as I mentioned, they're very dire. It can lead to all types of trouble regarding your finances and even your assets. The main forces of enforcing a judgment are, for example, bankruptcy. So if you owe £5,000 or more, then the creditor or the claimant may try to enforce that judgment by way of bankruptcy, which means that they would make you bankrupt. If you own a company, it may lead to a liquidation of the company, providing, depending on the amount of debt. It may also lead to instructing a bailiff coming to your house and seizing any assets that you have if you let that bailiff into your premises. Or alternatively, it may lead to an attachment of earnings order, which means that if you are working, then what they can do is they can contact the employer and have a certain amount of your wage every month deducted and paid directly to the claimant. The repercussions of having a judgment default against you is that it will affect your credit file immediately, and can affect your credit file and remain on your credit file for up to 6 years. And therefore that may affect you financially, such as getting a mortgage. It may restrict you from taking on any professions, such as being a director or an accountant or any financial advisor. So that's why it's best to deal with it head on and straight away to prevent those repercussions from taking place.
All right, and in the situation that, going back to the question we addressed before, in the situation that now you're dealing with a debt collection agency, is it possible that a debt can also be moved on completely to the agency or to a different company? For example, the example we dealt with already was where the company hires a third party to deal with it.
Yeah.
Is it possible that your entire debt could be sold on, and now you deal with someone completely different?
Absolutely, yes. A lot of what a lot of these companies do is they would sell the debt onto another company. For example, it may become part of their portfolio.
Okay.
And therefore a lot of companies out there, even solicitors firms, they may have a certain portfolio of clients where they have bought the debt from another company. And they would then be responsible for chasing that debt from the defendant. So yeah, it can be passed on, but they need to inform you in writing of that. They can't simply pass on the debt. If you're unsure as to whether it's been passed or not, you can always contact the court. This type of information would be in the public domain, and therefore you can contact the court, ask for court information, who's dealing with the debt, who do I owe the debt to. You can contact the claimant directly, but there are definitely ways out there to contact the agencies and find out who you owe the debt to, and to get that debt repaid.
Okay, and in the situation that you find yourself now, maybe because in today's society, possibly many of us owe debt, and you find yourself in a situation where you are being chased by someone for something you owe, and what are the things you should look out for? Because we find that in possibly every industry, you find there are people who act a bit unprofessionally. Yeah. And they try and take advantage of the situation, however it may be. Are there any very obvious things we can look out for if you owe a debt and you're being pursued by someone to retrieve it, whether on behalf of someone else or they've purchased it, and so on? Are there some obvious things we can look out for to know that this is a bit of funny business here?
Yeah, absolutely. I think we're all guilty of cutting the corner every now and then. What many a time happens is that the claimant would try to cut corners. They may, for example, be touching the boundaries of harassment. So if they're calling you night and day and on a regular basis, or they're trespassing on your property, then that would be a criminal offence. So there's chasing a debt, and again, there's harassment. If they're calling you night and day, then you need to report the matter. If they're trespassing on property, again, report the matter to the police. But there are only certain actions they can take. If it's a debt within the UK, then they need to make sure they comply with a CPR protocol and the guidelines that we have in place for us. If they've done anything which is fraudulent or anything which breaches or impedes on civil law, then they need to report the matter straight away. If the matter is already listed in court and it's being heard at court, they need to raise the attention of the judge to the actions of the claimant and of their solicitor if they have one instructed.
All right then, thank you so much. We've received a question from one of our viewers. Our question is: Assalamu alaikum. I have credit card debt before I start practicing my deen. It's about £10,000. I'm trying to pay it off, but my interest is very high, and because I am making minimum payments, I'm not really getting anywhere. I know riba is haram, and I am really stressed about this. Please, any advice on this? I work part-time. Now, I don't know if this is a legal question or
Yeah,
a fiqh matter.
exactly. I think it's touching the boundaries of fiqh. Obviously, interest for us is haram, but as far as the company who's chasing you, probably for them it's not haram. And therefore I don't think they'd be looking at that.
Yeah.
I think if a company is chasing you for a debt, then they would of course add interest to the debt, and the interest would be very high. You need to make sure that you get an arrangement put in place straight away. If a company is chasing you for a debt, you need to make sure that they are doing it legally. So for example, if they cannot simply issue a claim at court, and likewise they can't get judgment against you until they have followed the court process and procedure. So my advice to you would be to contact the company straight away and get an arrangement put in place. If you're working part-time, then make a reasonable offer that you can realistically and sustainably afford. There's no point in making an offer and getting an arrangement put in place and then you breaching the arrangement later on down the line, because then they can enforce their judgment against you. And therefore, look at your finances and make a realistic and reasonable, affordable offer to the company, and it would be in their interest to get an arrangement in place with you rather than to lose the debt altogether.
Okay, and is it ever possible, have you come across situations or know of companies or agencies which are willing to freeze the interest?
Yes, sometimes they would agree to freezing the interest, or they may agree to stopping the charges from accruing on the debt.
Okay.
That would be up to the company. So if you have a contract with a company, then you may want to check the terms and conditions of your contract and check whether they are allowed to charge interest and charges onto a debt. If they're not, then they're in breach of their own contract. So definitely check your contract and check what their own regulations, if they are governed by a body, then check what their body says.
Right then, thank you so much. I'll just take this quick chance to remind our viewers at home that this is Legal Hour. We're here every week, once a week, every Tuesday from the hours of 8:30 to 9:30 to take your questions and give you advice in regards to any legal matters you may be going through in the UK. So take the chance if you do have any questions or know any friends and family which may need some advice. Let them know that the show is here right now up until 9:30 today, and get in contact. The number is 0203 637 6857. That's 0203 637 6857. The topics we're specifically dealing with today are dispute resolution and enforcing a court judgment in regards to debt, or any other questions you may have if you're going through any financial difficulties right now in regards to owing a debt, or you're also able to ask us anything else regarding any legal matters you're going through, and we'll see if we can answer those as well, inshallah. Additionally, you're also able to get your questions to us via our WhatsApp service. Just send your question to our WhatsApp number on 074 2239 8833. That's on 074 2239 8833. So our next question is in regards to ticketing, getting the penalty for a parking ticket. Okay. We can see if we can get that answered. So if you get a ticket, is there a difference between receiving a ticket from a private company as opposed to receiving one from the council? The question goes on to explain that I've heard if you ignore the ticket received from you're able to ignore a ticket if you receive one from a private company, but they would like to know what the consequences are for that.
Okay, I certainly wouldn't advise ignoring a ticket, right. Because if you ignore a ticket, before you know it, they'll be having a judgment issued against you. Okay. I had a client very recently, in fact, where they had a series of tickets, a couple of tickets, and their colleagues were parking in the same spot. And therefore they thought that the company wouldn't take any action against them. And they therefore continued to park in that same location. After a few months, they then suddenly had a judgment issued against them. Their argument was that they didn't receive any letters from the company, they didn't know a claim had been issued against them, they didn't receive a letter before claim, and suddenly they had a judgment sitting on their table. And the judgment had already affected their credit file. And what therefore then happened was, instead of negotiating with the company and paying the debt off in installments, they had to pay off the whole lump sum debt within 28 days to prevent their credit file from being affected for a whole 6 years. And therefore, if you haven't received any correspondence from the company, or if you feel that they haven't taken any action, I wouldn't take that risk if I was you. because you don't know how many letters they have sent out, or on their records they may have certain records saying that they've sent out letters which you may have not received, and therefore it would be best not to bury your head in the sand, or hope for the best, ignore the ticket and tackle it head on and get it paid straight away. The other course, what we can't ignore is that these car parks are governed by CCTV.
Okay.
And they normally have a parking attendant walking around on a regular basis, and therefore you can't take the chance in saying that maybe they haven't spotted my car, because it will be monitored, and of course there will be records there proving that you're parked there from this time to this time and on these days. So these cases are very difficult to attack if they're not dealt with swiftly.
Okay, so legally that's a right an individual has, or an owner of a property has, to be able to place tickets on the vehicles of people who park there without their permission?
It depends, because if it's a private property and if somebody parks on your driveway, then obviously you can't do that because you wouldn't have the license to issue tickets.
Okay.
If you actually own a car park, or you're the council and you own a car park under a council license, then of course you can. But it's something that you need to check. If you received a ticket, you need to check the terms and conditions of the ticket on the back. Check on what basis it's been issued to you. Check who has issued the ticket to you, and then make sure you get that paid straight away. If you dispute the ticket, you would normally have 28 days or 21 days to appeal, and you would have an appeal process that you need to follow. If you don't follow their own appeal process, then they may hold that against you. So you need to make sure exactly what it says on the terms and conditions, normally on the back of the ticket. Okay,
so there definitely has to be a terms and conditions on the ticket.
It may be on the ticket, or it may refer you onto another a website or somewhere else where they will have the terms and conditions printed. But there will be somewhere where they have the terms and conditions. If you have the name of the company, you can always contact the company and ask them for the terms and conditions, or research the company online. Okay,
all right then. Thank you so much. So we have our next question now from our viewers. Our question is, Assalamu alaikum. I want to know, this regarding property law.
Okay.
Is that okay? So the question is, Assalamu alaikum. I want to know about my right in my husband's property. I'm separated with 2 girls from him. Can I claim anything? Our marriage is not registered. Thank you.
Okay. This is a crossover between property law and family law.
Okay.
As far as property law is concerned, I can answer the question. But if they have separated and obviously there are children involved, did I hear correctly? There are children
2
involved?
girls, yes.
Yes, in that case, you would need to see a family solicitor about that.
Okay.
Because you would need to obviously get specialist family advice with regards to what would happen to the children, what would happen to the family home. If you're both living in the home and it's regarded as a family home, again, you need specialist advice on that. And I would advise that you speak to a family solicitor on that issue.
So does it affect the wife's anything she's eligible for if there are children involved?
Of course, because if there are children involved, then you need to consider what's in the best interest of the children. And also, is the house in joint names? How long has it been regarded as a family home? How old are the children? Are the children dependent upon the parents? Who will the children be living with? What's the basis of their marriage breaking up? All of these considerations need to be taken into account. So that's why it's definitely better to speak to a family solicitor who has experience of this, and they can then tell you about what would happen if you take this line of action, what would happen to the family home, what would happen to the children, and what would happen to your finances, especially if the finances are in joint names.
All right then, thank you so much. Our next question regarding our topic today is, what are the different ways of enforcing a judgment?
Okay. So I touched upon this. The most effective way, of course, would be to instruct a bailiff. Providing you know where the defendant lives, you can instruct a bailiff and they would attend the property. A bailiff, this is a very important note that all of my brothers and sisters need to remember, a bailiff is not legally entitled to enter your property without your permission, and therefore if you don't choose to invite the bailiff into your property, a county court bailiff can't enter the property. If and when they enter your property, then they may have the power to seize any assets that are there, providing they are in your name. If, for example, they enter your property and you dispute the debt, they need to make sure you speak to the bailiff, tell them exactly what's happened, and tell them on what basis you dispute the debt. That's the first way. Another way may be to go down the attachment of earnings order route, which would be to contact your employer and get a part of your wages paid to the claimant until the debt is fully paid. Another way would be to consider bankruptcy or liquidation if you have a company. this would depend on the size of the debt that you owe to the creditor or to the claimant. And of course, another way would be to get a charging order placed on your property if the property is in your name. This would prevent you from then selling the property and would have a charge or an interest, or it may be unilateral notice registered against the property, which would prevent you from transferring the property or selling the property. If the debt remains outstanding and you choose not to contest or challenge that, it may lead to a final charging order, and it then may lead to ultimately a sale of the house until the debt is paid plus legal costs. So that's why it's very important to deal with the judgment straight away. The way to deal with a judgment is to either get the debt paid within 28 days, so the judgment doesn't show in your credit file at all and it's withdrawn. That would be the most effective way. The other way would be to make an application to court on a form N244, which is an application notice, in which you would need to prove to the court and persuade the judge that first of all the application was made promptly, so therefore promptitude is of fundamental importance. Secondly, you need to prove to the court that you have a reasonable chance of success in defending the claim against you. And thirdly, you need to prove that the judgment shouldn't be made against you in the first place.
I have to stop you there. We just have to take a short break and come back, and then we can continue with the question, inshallah, and with the rest of our questions. So for our viewers at home, thank you for watching so far. We're taking a short break for a few minutes, after which we'll be back up until 9:30 today, inshallah. So be sure to come back after the break. Assalamu alaikum wa rahmatullahi wa barakatuh to our viewers, and welcome back to Legal Hour, the show that's here every Tuesday, once a week, to address your questions regarding any legal matters you're going through or any situations legally you're going through, to give you some advice with our specialists today. So if you have any questions pertaining particularly to our topics today of dispute resolution and enforcing a court judgment in regards to debt, then you're able to contact us on 0203 637 6857. That's on 0203 637 6857. You're also able to send us your questions via WhatsApp on 074 2239 8833. That's on 074 2239 8833. So brother Suhail, before we went for the break, you were taking us through the different ways of enforcing a judgment. You went through 2 points and you were on your last one. If you'd like to finish.
Yes. So my last point was I was mentioning a charging order. So if, for example, a creditor is trying to enforce a judgment against you, and they've got to the point where they have registered an interest on your property, then if that's not contested or defended, it may lead to an interim charging order. And again, if that's not defended, it may lead to a final charging order, and that may ultimately lead to a sale of your house. And therefore, it's of vital and fundamental importance that you get that judgment contested straight away and get that charge lifted from your property. Otherwise, before you know it, you may be looking at sale proceedings. But those are the different ways that a judgment creditor may enforce a judgment against you.
Now, I was speaking about bailiffs before the break.
Yeah.
And I wanted to ask you regarding dealing with bailiffs, how are you able to deal with them if they come to your doorstep? And I don't know what a bailiff would say. I've never experienced it, but would they usually come with an attitude of they have the right to enter your home, or would they explain to you that you're able to let us enter or not let us enter?
Okay. Yes, with all due respect to a bailiff, I'm sure we have some callers who may be a bailiff. So a bailiff also should be respected, and there shouldn't be any hostility between the bailiff and the debtor. I know sometimes situations may get hostile, but the main thing to remember is that when a bailiff attends your property, they may say that they have a legal right to enter the property, or they may say that they've been instructed by the court to seize an asset, and therefore the defendant, being the owner of the property, has no choice but to let them in. It is your discretion, and it is at your prerogative that a bailiff may enter your property. If you allow them permission to enter your property, then they may seize an asset, but they cannot enter the property without your permission. But it is best to keep a distance, of course, respectfully from a bailiff, and to make sure that you have an arrangement set in place straight away to prevent a bailiff from visiting your property in the first place.
Okay. And if a bailiff, does the bailiff have the right to force their way into your home? If you open the door, are you now in trouble of them entering your home?
A bailiff cannot force their way into your home, but if, for example, you were to leave the front door open or unlocked, or if you were to leave any other door open, or maybe perhaps a window, then that's a possibility. I have heard of cases where a door has been left unlocked, and then suddenly, before you know it, a bailiff has entered the property, and the reason they have used it because a window or a door was left unlocked. And therefore, it's best to lock the doors and not to invite them in. But better than all of that, because what's going to happen then is, if you stop a bailiff from entering a property, they will attend the property again. And every visit they make to your property, they will be adding a charge onto the debt. And the charge can range between £50 to £100. And therefore, before you know it, a debt of £500 can suddenly become £1,500. And therefore, it's best that you contact the bailiff or the actual creditor and get an arrangement in place to prevent a bailiff from attending a property again and again.
So, of course, as we've been discussing, if it reaches the level that a bailiff has attended your property, there's been significant amount of contact being attempted to be made by the company or the individual who's chasing up the money you need to give them back.
Yeah.
There would have been letters, there would have been phone calls.
Of course.
You would have, if you do live there and a bailiff has come to your home knowing this is your address, then to that same address you would have received many attempts of contact. So it's not, it wouldn't usually be a surprise, would it?
No.
Okay.
I mean, the only way it may be a surprise to you is if, for example, you recently moved to the property, or you weren't aware of the debt, or perhaps you've moved to a property where the debt belongs to the previous owner, and therefore you weren't aware of it. I recently had a case where a couple of days ago, an owner had moved into the property, and a bailiff had entered the property, and they had actually entered the property at that stage, and they were refusing to leave until they had seized some assets. My client was trying to argue with the bailiff, saying that, look, the debt is not in my name. The debt was in the name of the previous owner who has now left the property. The property is in my name, and therefore this debt does not belong to me. In that circumstance, if the situation has become somewhat hostile, then rather than it getting out of hand, it may be best to contact the police or contact any other agency or maybe your solicitor to get the situation resolved. If it gets to a situation where there is trespass or any harassment, that would be a criminal offence.
Okay, then thank you so much. We'll go off to our next question from our viewers. Our question is: Assalamu alaikum. I have a flat in my name. I want to gift it to my 4-year-old to my 4 children. How do I go about it, and what are the implications?
Okay, this would be a question regarding either a deed or a trust left to children, or a gift. Because it's not pertaining to dispute resolution or a judgment, it would be best to speak to a solicitor specialising in either deed, trust, or gifting a gift to children. But there are many solicitors out there, and make sure they specialise in the area, and make sure you are aware of the financial repercussions and the regulations regarding it.
And what happens, just to stay on the topic just for a minute, what happens would it be considered, would dispute resolution would be relevant in the situation that a father or a parent passes away and they haven't written in their will anything regarding their children, and then amongst their children there's a dispute in regards to who should get what, or is there a particular system which is followed in this situation if it happens in regards to what they receive?
That would all depend on probate. So it depends on what's in the will of the deceased. So normally a will would be left, and it would ascertain exactly who would get what child would get what, who are the executors of the will, who are the personal representatives of the will, and it would be followed through by a probate solicitor. So it really depends on that. And the best thing to do is, if a will has been left, you need to take it to a solicitor who specialises in probate work, and ask them to read the will for you if you don't understand it, and they can then perhaps follow the probate through with you as well. If a will has not been left and the person has died intestate, which means there is no will, then again you need to seek the advice of a solicitor straight away to make sure you know and understand how the assets are divided amongst the spouse and amongst the children left in the family.
Okay, so in any case, it wouldn't be left to people to argue amongst themselves in regards to the will?
No.
Sorry, if there's no will.
Of course, disputes would arise. It's human nature for disputes to arise. Even where there is a will, disputes would arise regarding the validity of the will, regarding if one of the parties are arguing whether the deceased had mental capacity to leave the will or not, or to write the will at that time, regarding if the will is disputed itself, regarding the amount that the assets are worth. So a will can be contested in a whole manner of ways, and likewise, if the person has died intestate, again it can be disputed in a whole manner of ways, and that's why it's best that you speak to a probate solicitor specialising in contested probates, and they can advise you on that accordingly.
Thank you so much. It just came to my mind now, and it's something I noted to remember from last week's show. We had a question in regards to employment law, and our guest then specialised in a different field, so we weren't able to address it. Maybe is it possible to try and address it today? Maybe.
Yeah, it depends on the question.
We can try.
Yes.
Okay.
Yeah.
So our brother called us, one of our viewers, and explained that he worked at his workplace for less than a week.
Okay.
And then he was dismissed at less than a week. However, he feels that this was an unfair dismissal, and he'd like to know whether the amount of time he worked there would mean that him taking this forward, would it make it irrelevant, him taking it forward, or would it mean that it wouldn't be considered because he'd only worked there for such a short amount of time?
Okay, this would come down to what's written in the contract, and whether there was a breach of contract or not. If a person has only worked with their employer for a week, or less than a week, that will certainly affect their legal rights. Normally, if you worked for your employer for between a year to 2 years, then that would give you certain entitlements, certain legal rights. If the brother has only been there for less than a week, they need to check exactly what's in the terms and conditions of their contract of employment. Were they given a contract of employment? If they were, was it in written form? And check what would happen, on what grounds were they dismissed. Were they dismissed on grounds of performance, were they dismissed in breach of their own contract? If the employer is in breach of their contract of employment, they may potentially have a case. If there was no breach of contract of employment, they need to consider exactly what they're trying to get out of the contract. Are they looking for reinstatement? Are they looking for compensation? These are all matters they need to consider. And again, was there potentially an issue of discrimination? I would advise a brother to seek advice on this matter, and they can either come to the firm I work at, or they may approach any employment solicitor and then give them all the paperwork they need, and we can then give you full advice. Obviously, without the paperwork, I can only give generalist advice on this. But speak to an employment solicitor, give them the paperwork, give them a copy of your contract of employment, and they can then advise you fully on this.
Thank you so much. Our next question from our viewers is: Assalamu alaikum. I need some information about debt. I have too much to pay, but I don't have money to pay every time. The debt is over £30,000, and I'm thinking of going bankrupt, going forward with bankruptcy. Okay. Please let me know if this is the right way to go forward, and how long to get and how long to improve my credit score. It's written how long to get a better name. Does that mean anything legally?
A better name
possibly means better score rating.
Yeah.
So first of all, the brother is thinking of clearing for bankruptcy.
Okay.
He's like your advice, is that the right way to go forward in his situation?
Okay. Bankruptcy is a very bold decision to make, and you need to consider exactly what the repercussions would be financially on you. So if the brother, for example, it would depend on the job he's in, and whether bankruptcy, I know certain professions out there, for example, finance-related professions, they would not look kindly upon bankruptcy. And likewise, if the brother is in a business or owns a business, again, it may act as a detriment towards him. So he needs to consider his finances and his personal life as well, and his family life. Bankruptcy normally is considered as a last resort. If you have the finances, or you have the reasonable finances and affordable finances to consider arrangement being put in place, then you may want to consider that. But I think the best thing is to take your paperwork and show exactly what your debts are. If you're unsure about your financial situation, you may want to seek advice from a debt agency such as Citizen Advice Bureau or any of those agencies, and they can give you aided financial advice and help in negotiating an arrangement with the creditor. If you need a specialist legal advice, then speak to a solicitor who specializes in debt and bankruptcy, and they can then give you special advice after looking at your paperwork.
Thank you so much, Brother Suhail. I'd just like to take that chance to remind our viewers at home that we've been here from 8:30. This is Legal Hour. We're here every week, once a week, every Tuesday, from the hours of 8:30 to 9:30 to give you advice regarding any legal matters you may be going through. So if you have any queries or you'd like to join the discussion regarding the points we're discussing, then you can reach us on 0203 637 6857. That's on 0203 637 6857. Also, you can send us your questions to our WhatsApp number. All you have to do is type up your question on your phone and send it to 074 2239 8833. That's to 074 2239 8833. For everyone watching along on Facebook, you're able to leave your questions or your comments in the comment section. And if you'd like to take your time and type up your question, because there's quite a bit to it, then you're able to send us an email to legalhour@emanchannel.tv. That's legalhour@emanchannel.tv. So Brother Suhail will be going off for a break for Maghrib Adhan in just a few minutes, but we'll try and deal with the question before then.
Sure.
So I wanted to ask you regarding the efforts of a company to get in contact with the individual who owes the debt. Are there is there anything in place which means they can't disclose some information, or they can't share the fact that this individual owes a debt? For example, I'm calling your house, I'm looking for Suhail, and someone from your family picks up and I say that I'm looking for him, and the reason is that he owes a debt. Now we're trying to get our money back. Is this okay for them to do?
Ethically, no, it's not okay. It may be a breach of confidentiality, but it will happen. So if they're trying to chase a debt, there's really no way practically to stop that from happening. Many times it does happen. I have clients that it's happened too. But if it's in their contract that they have a confidentiality clause there, and they can't disclose that information to other household members, then you can raise that with them.
Okay.
But practically, it may be something that you can't really prevent them from doing.
Okay, unless there's a clause in the agreement.
Yes, if there's a clause there, then there would be in breach of the agreement, and therefore you can then seek redress of that clause and of that breach. But if there's no clause there, or in the absence of that clause, then it may be something that's difficult to prove or difficult to enforce.
All right, then, thank you so much. Our next question is, how do you contest the claim against you, and who do you go to help you with this?
Okay, so as far as defending a claim is concerned, so let's say, for example, hypothetically, that you receive a claim from the court saying that the claimant has issued a claim against you, and therefore you now have 21 days to respond. You would then be, it would then be in your interest to file a defense within 21 days. If you don't file a defense properly, as we mentioned, you can have a judgment in default made against you. If you file a defense, then the matter would be logged at court, and therefore the court would then give further direction. The judge would consider the claimant's claim and the defendant's defense. If the matter cannot be dealt with out of court, then the court would give directions as to exactly what would happen next. It may involve filing witness statements. It may involve further disclosure from both parties. It may involve a court directing both parties to settle out of court by way of mediation if the matter does not really seem like a court-related matter and like something that can be dealt with out of court. But what would happen next would be, after filing a defense, the matter would be given court attention, and direction would be given to both parties.
Thank you so much, Brother Suhail. May Allah reward you. We're going to go off for a short break for everyone watching at home for the Maghrib Adhan, and then we'll be back after that takes place, inshallah, to continue with the show up until 9:30 today, inshallah. So be sure to come back. Bismillah, salatu wassalamu ala rasulillah. Wassalamu alaikum to our viewers, and welcome back after the Maghrib Adhan to today's Legal Hour show. If you've just tuned in, then we've been here from 8:30 today to now. If it's the first time you're tuning into Legal Hour, you've just picked up the remote and switched on the TV and you found Legal Hour on, it's your first time watching it, then this show is all about giving you the chance to have access to an individual, to a solicitor, someone who knows about the British law, the legal British system, and is able to give you advice in regards to any matters you may be going through at the moment. Today's topics particularly we're dealing with dispute resolution and enforcing a court judgment in regards to debt or anything else in regards to debt for that matter. So if you'd like to call us up and take part in the discussion or have any questions you'd like to ask, then you're able to ring us on 0203 637 6857. That's on 0203 637 6857. That'll bring you right into the studio to speak to us. Otherwise, you also have our WhatsApp option where you can send your WhatsApp question to our number on 074 2239 8833. That's on 074 2239 8833. You also have our Facebook option and our email option. And all of these options should be coming and going throughout the duration of the show at the bottom right side of your screen, inshallah. So, Brother Suhail, we'll continue with our questions before leaving for the break. Our next question is, after contesting the claim or defending the claim, what can you what happens next? What can you expect to receive from the court? What are the following stages you should be looking forward to going through?
Okay, so if you have contested the claim and you feel that both parties are willing to consider mediation, normally what will happen is that once you receive court papers from the court, one of the boxes would be, are you willing to consider mediation to settle out of court? Of course, it would be advisable for you to tick yes, and then what would happen is that the mediator would contact you and they would try to attempt to settle the matter out of court by way of reaching a middle ground between the claimant and defendant. If that's not possible, the mediation has not resolved the situation, then the matter would proceed at court. You would then be given further directions from the court as to when disclosure would take place, whether both parties would be required to present a witness statement and file a witness statement to court, whether there would be any need for the matter to be considered to maybe the fast track or the motor track, depending on the complexity and the value of the case. And then you'd have to consider whether you would need to instruct a barrister to represent you at a hearing. But all of these matters will be dealt with in a very timely manner. So it won't be dealt with quickly, within a week or so. It will probably be stretched out to between 3 months to 6 months, depending on the complexity of the matter. It may even stretch out to over a year, depending on exactly what your defense was and the nature of the claim. But it's best to always consider out-of-court settlement because the courts are all very keen, and the judge likes attempts being made by both parties in trying to settle and avoid litigation in court.
Okay, thank you so much. So that takes us to our next question. What's the role of the judge in deciding whether a judgment can be made or not?
Okay, primarily the role of the judge is to consider whether any party would be prejudiced by the decision of a judgment. So if, for example, there is no defense filed by the defendant, the judge has nothing to work with, and therefore would simply consider the claim of the claimant, look at the CPI directions, consider the fact that the defendant has not filed a defense within the court stipulated time, and therefore a judgment in default would be made because no prejudice would be caused to the defendant. If a defendant has filed a defense, then the court would decide whether, again, any party would be at a detriment by making a decision, or whether the matter should be left to proceed to litigation or to possible mediation and out-of-court settlement. But the primary role is to exercise justice and promote justice within the courtroom and within the parties, and to make sure no party would be prejudiced by making a decision in favour of either party.
Thank you so much, Brother Suhail. Now, I'd like to go into asking you about credit scoring or credit score. We hear about it all the time. You know, we know about you needing a good credit score to get credit, and it's relevant to many contracts you may want to take part in, go into.
Yeah.
Or, can you give us more information in regards to what is a credit score? You know, what's its range? Because it's a score. We hear it's a score, and there are methods also to check what this is. I'm sure that there are some of our viewers know about this, and there's people that check it. But from a perspective of just hearing about it, what irrelevant information should we know about it, and how does it work?
Okay, essentially a credit score, again, I'm not a specialist in the field of credit scoring. This is something that certain agencies have been set up, such as Experian and other agencies out there. Essentially, a credit score is an analysis or a snapshot of your financial situation and of your financial condition. So if you have any arrangements put in place, have you taken out any credit within the recent years? Do you owe any debt to anybody? Do you have any judgments made against you? All of these matters will be shown up on your credit score or on your credit file. Essentially, every time you check your credit scoring, that check does show, and therefore it's advisable not to repeatedly check your credit score, but to make sure that you're comfortable exactly with the state of it. If you're unsure, then you can contact a specialist agency and find out exactly what your credit score is, how you can improve it, what it means, and to explain any factors that you may be unsure as to exactly, oh, what's happened there, why is there a glimp here, and just to get those matters clarified for you.
All right then. And just to clarify, the credit score is affected by you not paying your debt, correct? Or taking out debt or not sticking to a contract or making payments on time.
A credit score would be affected if you have a debt made against you. So even if you have an arrangement put in place whereby you're repaying the debt, that will still show sometimes as a positive, but it will still show as a mark on your credit score showing that an arrangement is put in place because of a payment plan being there.
All right, and going back to what we spoke about earlier, you explained that once it takes 21 days. Within 21 days, you need to respond to some correspondence which is sent to you.
So if a claim form has been issued against you, you need to respond
within 21 days.
It depends on the wording of the court order. Essentially, normally it's within 21 days to 28 days, but you need to respond.
You explained that if you do not respond within these days, then after that a judgment in default will be made, or it will affect your credit. Is it relevant to the credit score?
Yes. Okay. So if you don't respond within the stipulated time by the court, then if the claimant is clued up, then they will make sure that they apply for a judgment in default to be made against you.
Okay.
If that happens and the judgment in default is made against you, then it will affect your credit score and your credit file. But before that judgment in default is made against you, then you have that chance, you have that time to come to an arrangement or to put in a defense. But if that time lapses and you still haven't done it, and the claimant is watching the clock, then they can ask the court to enter that judgment against you.
All right then. So within this time, officially, this debt, or let's call it a problem, it doesn't affect your credit rating, your credit score. It doesn't affect you financially, correct? And you should take the opportunity to get in contact and make communication.
Yeah, absolutely. Yeah, you should make communication at all levels. Whether you have a claim issued against you, whether you have a letter before claim sent to you, whether the judgment has already been made against you, make sure you communicate straight away. Make sure you have the matter in hand. Make sure you contact the claimant or the creditor and get some sort of arrangement put in place to stop it from having further detrimental effects on you.
Thank you so much, Suhail. That brings us to the end of our show. Thank you so much for joining us today. We look forward to having you soon again. I'd like to thank our viewers, everyone who's watched along and everyone who sent their questions as well. Until next Tuesday at 8:30, be sure to tune back in then. For now, Assalamu alaikum wa rahmatullahi wa barakatuh.